Hi, this is Kimberly. We have finally come to part 4 of 4 of the Christopher McNabb and Cortney Bell trial, or should I say, of the 𝐬𝐭𝐫𝐚𝐥 McNabb trial. The reason for all these videos I've done, the reason for the trial, is the sweet cherub little baby 𝐬𝐭𝐫𝐚𝐥 McNabb. Callie was born a few weeks early, weighing just 5 pounds 6 ounces. At the time of her passing, she left behind her big sister Clarissa, also known as Rissa. She's called that by her pawpaw. I know the time Kalia spent with her pawpaw was warm, gentle, and caring. I know this because my husband is a pawpaw. He's the exact same way, and if I'm not mistaken, Mr. Bell still cares for and has physical custody of Rissa to this day, who no doubt misses Sissy and her parents. But she is the best place she can be if she's with pawpaw. Mark my words. Correct me if I'm wrong, but Judge Ott clearly has a preference of Miss Zon. She's married, but Mrs. Zon doesn't sound right. I like Miss Zon, the way Judge Ott calls her that, but I could just never, ever picture him going off on her as he has done with others in the courtroom. Even when he corrected Shane Kidd for continuing to talk when an attorney had an objection, he did it with respect, as opposed to, say, when he spoke to Megan Sorrells. Wearing those stilettos not only make Miss Zon attractive with her butt sticking out, but it makes her a powerful force to be reckoned with. Side note, did you know that high heels were invented by a man? Go figure. Same with a bra. The day the jury took a field trip out to the trailer park and then hiked through the woods, Miss Zon looked like any other young lady of her age. The field trip was played a couple of episodes back in case you missed it. But now that Miss Zon is a judge, she can kick off those stilettos and put on some fuzzy slippers and no one will be the wiser. Yeah, she was prancing around the courtroom in her stilettos. Surely a sight for Judge Ott up there in his bird's eye view seat. But this episode has a surprise for you. I sure didn't see it coming, but you're guaranteed to be left with your mouth hanging wide open, all undignified like and shit. But back to baby Kalia and her sorely deficient parents. The newborn spent 4 days in the hospital before her parents left her first with cousin Megan for 2 days, and then Belle's father for at least 2 days, if not more, Miss Zon said. And she perhaps spent a night or two, or at least a day or so, with Missy Davis, who also lived in the trailer park, who is Craig Weatherford's girlfriend's mother. And she smokes meth too. But little baby Kalia spent no more than a handful of days with mommy and daddy. Kalia's birth mom, Cortney Marie Bell, age 23, and birth father, Christopher McNabb, was 27 when she was born. On the Friday night of October 6, 2017, after putting the baby and the couple's 2-year-old to bed, Bell and McNabb set out for a relaxing night of smoking meth. Courtney's cousin Craig stopped by for a while. He claims to have seen the baby sleeping soundly in her little infant crib. Chris and Courtney spent the evening, according to their accounts given to law enforcement, intermittently changing diapers, feeding the baby bottles, taking a shower. Showering. Why can't I say showering? Oh, showering, or at least Chris did, because he changed his boxers. He had been wearing the other pair 5 days, he said. But intermittently changing diapers, feeding the baby bottles, and on one occasion, Chris took the newborn outside on the porch to avoid subjecting her to smoke inside the trailer. Both meth smoke and cigarette smoke. Probably weed smoke too. And sometime during the night, they, as investigator Jeff Alexander worded it, had sex of some kind, even though Courtney was only 2 weeks postpartum. Throughout the night and into the early morning hours, Chris was getting to know a new girlfriend through Facebook Messenger. On October 7th, 2017, Bell called 911 to report the baby was missing from the family's mobile home. This launched a frantic search within the community. Before needlessly alerting authorities, Chris and Cortney exhaustively searched under both porches of the mobile home, underneath the motorhome, the oven, the refrigerator, the garbage can, and inside several totes for their newborn. They cooperated with the sheriff's office and each gave an interview that day. Later that evening, McNabb publicly lost his shit for all to see in front of television cameras. I think he was strongly requesting 𝐭𝐫𝐤𝐿's return. He was hollering, "I want my kid, man. I want my kid back, man. That's my child." And then he repeated it before storming off to the motorhome where he resided with his cousin, who is also his main girlfriend, Cortney. His words are pure poetry. Although this brief interview didn't showcase McNabb's bad grammar, his 3 motor-mouth interviews, totaling around 5 to 6 hours, certainly did. 15-day-old 𝐭𝐫𝐤𝐿 was found late Sunday morning, wrapped inside a blue drawstring bag underneath a log, not far from where her parents lived in the Eagle Point Trailer Park in Newton County, the city of Covington, Georgia. 2 days later, the medical examiner revealed on October 10th that she had died from blunt force trauma to her little head, her little soft newborn head. In January 2018, a grand jury indicted both Chris and Cortney, him on 8 counts including malice murder, felony murder, second-degree murder, aggravated battery, and concealing the death of another. The grand jury indicted Bell on second-degree murder, child cruelty, and child deprivation charges. And that's where we are now. The trial is finished. The closing arguments have been done on this day, May 14th, 2019, 2 years later. Miss Layla Zon decided to go last with her closing arguments. She knew she could deliver the most impact that way, and bloody right, you were damn straight she did. Miss Zon is roughshod and savage. She's strong like ox. She's good. I would hate for her to yell at me, or worse, to be my mom or something. Good God Almighty, Kimberley, were you batshit crazy scared of Miss Zon or something? Yes. I was scared. She scared me. She was hollering and I got scared. Miss Zon was hollering. Aunt Kim was hollering. Cortney was hollering. Aunt Pam was hollering. I don't like hollering. It makes me scared. You know what I mean? You know what I mean? I was scared. For those that want to reside in Newton County, Georgia in the future, I offer a few words of advice. It might be prudent to never, ever underestimate Miss Zon, who is now a Superior Court judge. Just don't fuck up. And today, in this video, she still has a jaw-dropper, plot twist, turn of events. So, I'm going to shut the fuck up now so Judge Ott can talk. Please enjoy episode 31 of As the Mobile Home Park Wheels Turn. I hope you've enjoyed this series as much as I have. Much love and peace. Thank you for listening.
Now let me ask one more time while on break for lunch, did anybody attempt to talk to you about this case? You hear anything you're not supposed to hear? You see anything on social media, on the computer? Read any newspapers or anything, TV at all? Okay. I'm going to start reading this the jury charge to you. As the attorneys have each pointed out to you, these are 2 separate cases against each defendant. You'll have out 2 different verdict forms as to each defendant. You'll have 2 separate indictments against each defendant. Any evidence in the case, if you do find there's evidence against a defendant, you have to determine whether that evidence is also against the other defendant, and if not, you can't use that evidence on the other defendant. Is that clear to everybody? Okay, let me start. You are considering the cases of the state of Georgia versus Christopher Michael McNabb and Cortney Marie Bell. Defendant McNabb has been accused of the offenses of in count 1, malice murder, count 2, felony murder with aggravated battery being the underlying felony, count 3, felony murder with the underlying felony being cruelty to children in the first degree, count 4, murder in the second degree, count 5, aggravated battery, count 6, cruelty to children in the first degree, count 7, cruelty to children in the second degree, and count 8, concealing the death of another. These charges, I'm going to read to you how the indictment lay them out. In count 1, the grand jurors selected, chosen, and sworn for the county of Newton on behalf of the citizens of the state of Georgia do hereby charge and accuse Christopher Michael McNabb with the offense of malice murder. For that the said accused on or about the 7th day of October 2017 in Newton County, Georgia, then and there, did unlawfully with malice aforethought cause the death of 𝐭𝐫𝐢𝐚𝐥, a human being, by inflicting blunt force trauma upon her head in violation of 𝐬𝐭𝐫𝐚𝐥 section 16-5-1 subpart A, contrary to the laws of this state, the good order and peace and dignity thereof. In count 2, the grand jurors charged the defendant with the offense of felony murder. For that said accused on about the 7th day of October 2017 in Newton County, Georgia, then and there, while in the commission of the felony offense of aggravated battery, as alleged in count 5 of this indictment, did cause the death of 𝐭𝐫𝐢𝐚𝐥, a human being in violation of 𝐬𝐭𝐫𝐚𝐥 section 16-5-1 subpart C, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 3, the grand jurors charged the defendant with the offense of felony murder. For that the said accused on or about the 7th day of October 2017 in Newton County, Georgia, then and there, while in the commission of the felony offense of cruelty to children in the first degree, as alleged in count 6 of this indictment, did cause the death of 𝐭𝐫𝐢𝐚𝐥, a human being, by maliciously causing said 𝐭𝐫𝐢𝐚𝐥 cruel and excessive physical pain, by inflicting blunt force trauma upon said child to her head, in violation of 𝐬𝐭𝐫𝐚𝐥 section 16-5-1 subpart C, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 4, the grand jurors charged the defendant with the offense of murder in the second degree, for that the said accused on or about the 7th day of October of 2017 in Newton County, Georgia, then and there did commit the offense of murder in the second degree, when the accused caused the death of 𝐭𝐫𝐢𝐚𝐥, a human being, irrespective of malice, while in the commission of cruelty to children in the second degree, as alleged in count 7 of this indictment, by causing said 𝐭𝐫𝐢𝐚𝐥, a child under the age of 18 years, cruel and excessive physical pain, by inflicting upon her blunt force trauma to her head, in violation of 𝐬𝐭𝐫𝐚𝐥 section 16-5-1 subpart D, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 5, the grand jurors charged the defendant with the offense of aggravated battery. For that the said accused on or about the 7th day of October of 2017 in Newton County, Georgia, then and there, did maliciously cause bodily harm to 𝐭𝐫𝐢𝐚𝐥 by rendering her brain, a member of said person's body, useless, said 𝐭𝐫𝐢𝐚𝐥 being the child of said the accused in violation of 𝐬𝐭𝐫𝐚𝐥 16-5-24, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 6, the grand jurors charged the defendant with the offense of cruelty to children in the first degree. For that the said accused on or about the 7th day of October 2017 in Newton County, Georgia, then and there, did maliciously cause 𝐭𝐫𝐢𝐚𝐥, a child under the age of 18 years, cruel and excessive physical pain, by inflicting blunt force trauma upon said child to her head, in violation of 𝐬𝐭𝐫𝐚𝐥 section 16-5-70, contrary to the laws of this state, the good order, peace, and dignity thereof. Count 7, the grand jurors charged the defendant with the offense of cruelty to children in the second degree. For that the said accused on or about the 7th day of October of 2017 in Newton County, Georgia, then and there, did with criminal negligence cause 𝐭𝐫𝐢𝐚𝐥, a child under the age of 18 years, cruel and excessive physical pain by inflicting blunt force trauma upon said child to her head, in violation of 𝐬𝐭𝐫𝐚𝐥 section 16-5-70, subpart C, contrary to the laws of this state, the good order, peace, and dignity thereof. Finally, in count 8, grand jurors charged the defendant, Christopher Michael McNabb, with the offense of concealing the death of another. For that the said accused on or about the 7th day of October of 2017 in Newton County, Georgia, then and there, did unlawfully conceal the death of 𝐭𝐫𝐢𝐚𝐥, which hindered the discovery of whether or not said person was unlawfully killed, by placing her body in a drawstring bag and placing said drawstring bag containing her body into an indentation in the woods in violation of OCGA Section 16-10-31, contrary to the laws of this state, the good order, peace, and dignity thereof. Now, defendant Cortney Bell has been charged by indictment with 3 counts. In count 1, murder in the second degree. In count 2, cruelty to children in the second degree. In count 3, contributing to the deprivation of a minor. Her indictment reads as follows. In count 1, the grand jurors selected, chosen, and sworn for the county of Newton on behalf of the citizens of the state of Georgia do hereby charge and accuse Cortney Marie Bell with the offense of murder in the second degree, for that the said accused on or about the 7th day of October 2017 in Newton County, Georgia, then and there did commit the offense of murder in the second degree, when the accused caused the death of 𝐬𝐭𝐫𝐚𝐥, a human being, irrespective of malice, while in the commission of cruelty to children in the second degree, by causing said 𝐬𝐭𝐫𝐚𝐥, a child under the age of 18 years, cruel and excessive physical pain through the infliction upon her a blunt force trauma to her head in violation of OCGA Section 16-5-1D, contrary to the laws of this state, the good order, peace, and dignity thereof. In count 2, the grand jurors charged the defendant with the offense of cruelty to children in the second degree, for that the said accused on or about the 7th day of October 2017 in Newton County, Georgia, then and there, did with criminal negligence cause 𝐬𝐭𝐫𝐚𝐥, a child under the age of 18 years, cruel and excessive physical pain through the infliction upon her of blunt force trauma to her head in violation of OCGA 16-5-70C, contrary to the laws of this state, the good order, peace, and dignity thereof. Finally, in count 3, the grand jurors charged and accused the defendant with the offense of contributing to the deprivation of a minor, for that the said accused on or about the 7th day of October of 2017 in Newton County, Georgia, then and there, did willfully fail to provide proper parental care or control for 𝐬𝐭𝐫𝐚𝐥, a minor child under the age of 18 years, and failed to provide said child with adequate supervision necessary for such child's well-being, said act resulting in 𝐬𝐭𝐫𝐚𝐥 being a deprived child in accordance with the provisions of Code Section 15-11-2 of the Official Code of Georgia, and said act resulting in the death of said child in violation of OCGA Section 16-12-1, Subpart B, Subpart 3. Contrary to the laws of this state, the good order and peace and dignity thereof. Both of these indictments were returned in open court as required by law. Each defendant has entered a plea of not guilty to these indictments. The indictments and the pleas form the issues that you are to decide. Neither the indictments nor the pleas of not guilty should be considered as evidence. Each defendant is presumed to be innocent until proven guilty. The defendants enter upon the trial of the case with a presumption of innocence in his and her favor. This presumption remains with the defendants until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that a defendant is guilty of the offense or offenses charged. Facts and circumstances that merely place upon a defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of a defendant's guilt, are not sufficient to authorize the conviction of that defendant. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. There is no burden of proof upon a defendant whatsoever, and the burden never shifts to a defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the defendant or a defendant beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied concerning a defendant, then that is a doubt of the law, and you must acquit that defendant. But if that doubt does not exist in your minds as to the guilt of a defendant, then you'd be authorized to convict that defendant. If the state fails to prove a defendant's guilt beyond a reasonable doubt, it would be your duty to acquit that defendant. A jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. When you consider the evidence in this case, if you find a conflict, you should settle this conflict if you can without believing that any witness made a false statement. If you cannot do this, then you should believe that witness or those witnesses you think best entitled to believe. You must determine what testimony you will believe and what testimony you will not believe. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial attorney's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all witnesses' issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case is under no duty to present any evidence tending to prove innocence, and is not required to take the stand and testify in the case. If a defendant elects not to testify, no inference hurtful, harmful, or adverse shall be drawn by the jury, nor shall such fact be held against the defendant in any way. In assessing the credibility of a witness, you may consider any possible motive in testifying, if shown. In that regard, you are authorized to consider any possible pending prosecutions, negotiated pleas, grants of immunity or leniency, or similar matters. You alone shall decide the believability of the witnesses. Sometimes evidence is admitted for a limited purpose, or against one defendant and not the other defendant. Such evidence may be considered by the jury against a defendant for which the evidence is limited and not for any other purpose. Any out-of-court statement made by one of the defendants on trial in this case after the alleged criminal act has ended may be considered only against the person who made the statement, and only if you find that such statement was freely and voluntarily made. If you find that an out-of-court statement was made to the police freely and voluntarily by a defendant on trial in this case, then you are to consider that statement only as against the particular defendant who made it. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in this charge to the facts as you find them to be. Each defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be in your discretion inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. The defendants will not be presumed to have acted with criminal intent, but you may find such intention, or the absence of it, upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which an accused is being prosecuted. The jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a defendant who was merely associated with other persons involved in the commission of a crime, guilty of a consent in and concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits submitted during the trial. It also includes stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. Evidence does not include the accusation, the plea indictments, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You'd be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. Testimony has been given by certain witnesses who in law are termed experts. The law permits persons expert in certain areas to give their opinions derived from their knowledge of that area. The weight which is given to the testimony of expert witnesses is a question to be determined by the jury. The testimony of an expert like that of any other witness is to be received by you and given only such weight as you think it is properly entitled to receive. You're not required to accept the opinion testimony of any witness, expert or otherwise. Christopher Michael McNabb is charged with the offenses of malice murder, 2 counts of felony murder, murder in the second degree, aggravated battery, cruelty to children in the first degree, cruelty to children in the second degree, and concealing the death of another. Cortney Bell is charged with the offenses of murder in the second degree, cruelty to children in the second degree, and contributing to dependency or deprivation of a minor. I'm going to now define these offenses for you, and I'll tell you when I give a definition who it applies to. For malice murder, it'll be the count 1 against Christopher McNabb. A person commits murder when that person unlawfully and with malice aforethought, either expressed or implied, causes the death of another human being. Express malice is the deliberate intention unlawfully to take away the life of another human being, which is shown by external circumstances capable of proof. Malice may, but need not, be implied when no considerable provocation appears and when all of the circumstances of the killing show an abandoned and malignant heart. It is for the jury to decide whether or not the facts and circumstances of this case show malice. To constitute murder, the homicide must have been committed with malice. That's malice murder. To constitute malice murder, the homicide must have been committed with malice. Legal malice is not necessarily ill will or hatred, but it is the unlawful intention to kill without justification, excuse, or mitigation. If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes malice murder. Georgia law does not require premeditation, and no particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantly a mortal wound may be inflicted. Yet, if malice is in the mind of the accused at the time of the doing of the act or killing and moves the accused to do it, such is sufficient to constitute the homicide as murder. Proof of a particular motive is not essential to constitute the crime of murder. Evidence of motive, if any, is omitted for your determination as to whether or not it establishes the state of the defendant's mind at the time of the alleged homicide. I'm next going to define for you the 2 counts of felony murder against Mr. McNabb. A person also commits the crime of murder when in the commission of a felony that person causes the death of another human being with or without malice. Under the laws of Georgia, aggravated battery, cruelty to children in the first degree are felonies, and these are defined as follows. And I'm only going to define them one time, even though they're also in other parts of the indictment. I'm going to define these crimes to you one time. Aggravated battery. A person commits the offense of aggravated battery when he or she maliciously causes bodily harm to another by rendering a member of her body useless. Cruelty to children in the first degree is defined as follows. Any person commits the offense of cruelty to children when that person maliciously causes a child under the age of 18 cruel or excessive physical pain. Now, in these 2 definitions of aggravated battery and cruelty to children in the first degree that I've just read to you, the term maliciously is used. Malice is not ill will or hatred. Malice means an actual intent to cause the particular harm produced, that is, physical pain, without justification or excuse. Malice is also the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such particular harm may result. Intention may be shown by the circumstances connected with the offense. If you find and believe beyond a reasonable doubt that the defendant committed the homicide alleged in the bill of indictment against defendant McNabb, at the time the defendant was engaged in either the commission of the felony of aggravated battery or the felony of cruelty to children in the first degree, or both, then you'd be authorized to find the defendant guilty of felony murder, whether the homicide was intended or not. In order for a homicide to have been done in the commission of this particular felony, there must be some connection between the felony and the homicide. The homicide must have been done in carrying out the unlawful act and not collateral to it. It is not enough that the homicide occurred soon or presently after the felony was attempted or committed. There must be such a legal relationship between the homicide and the felony so as to cause you to find that the homicide occurred before the felony was at an end or before any attempt to avoid conviction or arrest for the felony. The felony must have a legal relationship to the homicide, be at least concurrent with it in part, and be a part of it in an actual and material sense. A homicide is committed in the carrying out of a felony when it is committed by the accused while engaged in the performance of any act required for the full execution of the felony. A criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death actually occurred. If a dead body is discovered in this state and it cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. Now, each defendant is charged with murder in the second degree, which I'll define for you. A person commits the offense of murder in the second degree when in the commission of cruelty to children in the second degree, he or she causes the death of another human being under the age of 18, irrespective of malice. Cruelty to children in the second degree are charged against each defendant. Any person commits the offense of cruelty to children in the second degree when such person with criminal negligence causes a child under the age of 18 cruel or excessive physical pain. Criminal negligence is defined as criminal negligence is an act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured thereby. Mr. McNabb is charged with concealing the death of another person. A person commits the offense of concealing the death of another person when that person hinders a discovery of whether or not such person was unlawfully killed. Defendant Bell is charged with contributing to the delinquency or deprivation or dependency of a minor. A person commits the offense of contributing to the deprivation or dependency of a minor or causing a child to be placed in need of services when such person willfully commits an act or acts or willfully fails to act when such act or omission would cause a minor to be adjudicated to be a dependent child. Dependent child means a child who has been abused or neglected and is in need of the protection of the court. Georgia law provides that being under the influence of drugs shall not be an excuse for any criminal act. It further provides that if a person's mind, when not affected by drugs, is capable of distinguishing between right and wrong, as well as of reasoning and acting rationally, and the person voluntarily deprives himself or herself of reason by consuming drugs and commits a criminal act while under the influence of such drugs, the person is criminally responsible for such acts to the same extent as if the person were not under the influence of drugs or sober. Whether or not a defendant in this case was voluntarily under the influence of drugs at or during the time alleged in these indictments is a matter solely for you, the jury, to determine. Now, if after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant Christopher Michael McNabb in Newton County, Georgia, then on or about October the 7th of 2017, commit malice murder, 2 counts of felony murder, aggravated battery, cruelty to children in the first degree, cruelty to children in the second degree, and consenting to the death of another, or any one of these offenses, you'd be authorized to find this defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If after considering the testimony and evidence presented to you together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant, Cortney Bell in Newton County, Georgia, did on or about October the 7th of 2017 commit murder in the second degree, cruelty to children in the second degree, and contributing to deprivation of a minor, or any one of these offenses, you'd be authorized to find this defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that either the defendant is guilty of the offenses against them or of any one of the offenses, or if you have any reasonable doubt to a defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of the other. You, the jury, must determine the guilt or innocence of each defendant separately. You are only concerned with the guilt or innocence of the defendants. You are not to concern yourselves with punishment. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated and returned to be published in open court. I've indicated to you that we'll have separate verdict forms prepared for each defendant. Each of them the same. At the top of the case is the style of the case. It says verdict. It says, we, the jury, find as follows, either guilty or not guilty, and it lays out each of the counts, and it has, we find the defendant, and with the blank spaces, you put in the words or word that reflect your verdict, a place for it to be dated, and for the jury foreperson to sign. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberation, who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, consult with one another, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after the discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. And by no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of either defendant. I'm going to allow you to retire to the jury, but I don't want you to begin your deliberations until you receive the indictments and any evidence that's been admitted in the case, and the verdict forms. I tell all jurors at this time that once the evidence is closed, I can't add facts to the case. When you get back there, if you have a question, you're to write it down on a sheet of paper, knock on the door, and the bailiff will bring it to me. I'll get everybody out here and we'll discuss it. But if what you're seeking is additional facts, then I'll write back to you and say, I'm sorry, the evidence is closed, I can't add to the facts. But that's not to limit your questions. You let me make that decision and send it on out. That's going to conclude my remarks now. I'm going to need Mr. Robinson and Ms. Burke to follow another boat. If y'all are the alternate jurors, you'll follow this gentleman right here. The remainder of you go back into the jury room. Satisfied the only evidence going out that's been properly admitted?
I am. Yes, sir.
Mr. Frost, you too?
Yes, sir.
Good. Set it down, let the bailiffs carry that, Mr. Frost, Mr. Steve, any objections to the charge? No. Mr. Carter?
No, sir.
Mr. Frost?
No, sir.
We're going to be in recess till we hear something further from the jury. Y'all don't wander it far at all, because if they have a question, I want to immediately be able to convene, talk about it, and do something. We'll be in recess. Okay, I understand they have arrived at a verdict. Does the state wish to receive the verdict or wish the court to publish the verdict?
Let the court publish it.
Okay. Bailiffs, when they come out and we ascertain who the foreperson is, I want you to bring the verdicts to me. Okay? Anything else?
No, sir, Your Honor.
Now, as always, I don't want any outburst in my courtroom, so if anybody, I want you to think what it'd be like if the verdict's against what you want. And if you need to leave, go ahead and leave now. Nobody's leaving, so I think we're ready. Bring the jurors in. Each verdict form reads, in each of the counts against each defendant, we, the jury, find the defendant guilty. That's all 3 counts against Ms. Bell and all 8 counts against Mr. McNabb. Is there anything further required of the jury?
Yes, Your Honor, that's what you told the jury.
Okay. Except for the alternate jurors where you don't have to answer. I'm going to start with the jury foreperson. I'm going to go down to you, then I'm going to skip back to the second row, go this way, and then I'm going to skip back to the third row and finish up. Except for the alternate jurors, y'all don't answer. Mr. Foreperson, is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into? Was it freely and voluntarily entered
Oh,
into?
yes, sir. Yes, sir.
Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
Yes.
Is it a true verdict? Was it freely and voluntarily entered into? Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
Yes,
Is it
sir.
a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict? Is it a true verdict? Was it freely and voluntarily entered into? Is this your verdict?
Yes, sir.
Is it a true verdict?
Yes, sir.
Was it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
Yes, sir.
Was it a true verdict?
Yes,
Was
sir.
it freely and voluntarily entered into?
Yes, sir.
Is this your verdict?
Yes, sir.
Was it a true verdict? Was it freely and voluntarily entered into? Is this your verdict? Was it a true verdict? Was it freely and voluntarily entered into? Anything further required?
No, sir, Your Honor.
If y'all, all of the attorneys come forward and look at these verdicts to see that they're in its proper form. Each is dated and signed by the foreperson.
Here's to me, Your Honor.
Mr. Frost,
Yes, sir.
I'm going to order that be filed with the court. Ladies and gentlemen of the jury, I certainly do appreciate your service. A difficult case, very emotional case. I always want to thank the alternate jurors who had to sit through the case without the deliberation phase of it. I really do appreciate your effort. I'm going to go ahead and excuse y'all, so I'll excuse you. Now, we have the media around. Whether y'all talk to media or not talk to media, that's up to y'all. You understand me clearly. Nobody can make you, and nobody can prevent you. Is that clear to everybody? Okay, you excuse me for the attendance on the court. Thank y'all. Need you to calm down.
I'm good, I'm just saying, I'm
You said it 5 times.
giving my views, that's all.
Let's take Mr. McNabb out of the courtroom. Y'all all be seated. I'm going to have the defendants brought out one at a time to go to sentencing and a sentencing hearing. Mr. McNabb is going to be placed, of course, in cuffs. I'm not going to, when I say I'm not going to tolerate outbursts, I don't know, nobody has control over Mr. McNabb, Mr. Carter. I don't believe you've got any control over him either. But if, in fact, I can't talk to him in any kind of way, and he continues with these outbursts, well, we got it live streamed. I'm going to put him back in the back room with a computer or something. That's why I called you out, to see if we've got any ability, if anybody's got a computer or a laptop, and if you have somebody from your office that you would want to come sit with him. I need to know that, and you need to get him on up here.
Yes, sir.
But I'm going to give him a chance first to see if he'll behave out here before I get into that. So, I'm going to let you go make a phone call. Do you want to get somebody up here in case we have to send them back?
Mr. Hall's here.
Okay, then that'd be sufficient. Okay. My next question is, do we have the ability to live stream back there?
No, sir.
You say no. I just meant there, do we have, I don't know. I've got all these brains out here. Y'all tell me something.
Right, it wouldn't be high-tech live streaming, it would be more like FaceTiming or something.
FaceTiming.
That's the best I could come up
I
with.
could pull up my phone right now and pull up Court TV, for instance. They're live streaming the thing.
Right.
You just see it on your phone. There's no, you could do it on a computer if you had the computer and you had the Court TV, if you had the app for the Covington Facebook page, which you could get up on a laptop, and then just, sit there and they'd see the whole thing.
Right.
What do you suggest, Mr. Carter? Would it do any good for you to go back there and talk to him?
It would, yeah.
Why don't you go back and talk to him while I sit out here, and you tell me after you've talked to him, or whether we got some kind of assurance. Well, that's the worst. That's what we'll do. Yeah. Before we bring them out here, let's get straight. We're going to bring out Mr. McNabb first. We've had a kind of a preliminary discussion back in my chambers on Wednesday morning about this. I'm going to direct both the state and Mr. Carter. The court will sentence on malice murder. By law, counts 2 and 3 of felony murder are vacated. Murder in the second degree would merge. I've been told that the aggravated battery merges also. That cruelty to the children in the first and the second degree are all about the blunt force trauma. So each of those merges into count 1. And finally, count 8, concealing the death of another, you have to be sentenced on that too. Is that 10-year sentence?
Yes, sir.
Okay. Is everybody ready?
Yes, sir.
Bring out Mr. McNabb. Are y'all ready for the sentencing hearing? You may be seated, Mr. McNabb. Let's turn to the sentencing hearing. And does the state have anything it wishes to offer in the way of aggravation?
Yes, Your Honor. We have several certified copies of convictions as well as one witness that I believe is on her way here in the courthouse. The first would be State Exhibit number 137, which is a certified adjudication order from juvenile court, case number 107-01J-0625 and 107-01J-0611. That is for disorderly conduct, where the defendant was adjudicated delinquent for that offense as a juvenile in June of 2001. State's Exhibit number 138 is also an adjudication order for case number 1007-00J-1281 and 1354, where the defendant was adjudicated delinquent for simple battery as a juvenile in January of 2001. Also case number 107999J702. This is State's Exhibit 139, which is an adjudication order from juvenile court for simple battery from November of 1999. We also have a Superior Court conviction out of the Superior Court of Bartow County. The defendant was convicted in Bartow County for theft by taking, entering a motor vehicle to commit a theft, criminal damage to property, burglary. He was sentenced on case number 2007-1989, and that was in October of 2007. That was State's Exhibit number 140. State's Exhibit number 141 is a criminal conviction for the Superior Court of Newton County, case number 2013 CR 1263-5. The defendant was convicted of theft by shoplifting and giving false information to a police officer. He was adjudicated guilty or sentenced on this particular case in the October term of 2013, and that's again State's number 141. Also State's number 142, which is a Superior Court of Newton County conviction on case number 2015 CR 02-5, where the defendant was convicted of obstruction of an officer. That again was a sentence from the January term of 2015. The state offers State's Exhibit number 143, which is the Superior Court conviction out of the Griffin Judicial Circuit, where the defendant, Christopher Michael McNabb, was convicted of obstructing and hindering a law enforcement officer felony, driving while license is suspended, driving on the wrong side of the roadway, speeding, stop sign violation, and failure to maintain lane, and that was in August of 2001. State offers Exhibit number 144, which is a conviction out of Coweta County on case number 2013-0190. And there the defendant was convicted of one count of theft by taking, and that was in, looks like February of 2003. These are all certified copies of convictions that the state has for Christopher Michael McNabb, and I'm showing them to Mr. Carter now.
Judge, I have no objection to Exhibits 140 through 144. I do object to the misdemeanor juvenile delinquent juvenile adjudications.
Judge, I know the law is clear that anything can be used in aggravation, so juvenile adjudications are admissible. I have one witness.
Well, let me finish with this first, Ms. Zon. I'm going to admit everything into evidence. If it makes any difference to you, the misdemeanors mean nothing to me, Mr. Carter.
Yes, sir.
And I would not enhance sentencing at all because of the misdemeanors.
Yes, sir.
Now, Ms. Zon,
Your Honor, the state calls Priscilla Faulkner, Dr. Priscilla Faulkner. Could you raise your right hand, please? Do you swear or affirm that the testimony you're about to give in the matter now pending before this court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you. Please state your name.
Priscilla Faulkner.
And you are a doctor?
I am.
And a doctor of what?
Psychology.
I want to draw your attention back to October the 14th of 2017. Did you have the occasion to go to the Newton County Detention Center to have contact with Christopher Michael McNabb?
I did.
What was the nature of that contact?
Your Honor, I'm going to object because the notice of this aggravation was only provided to me last night.
why is that a concern?
Because it should have been provided prior to trial, and it was only provided last night.
Ms. Zon?
Well, Judge, I learned of it yesterday, and I reached out to Dr. Faulkner and spoke with her to confirm the veracity of this. I let Mr. Carter know last night, and Mr. Carter notified me this morning that he was already aware of this. So he's known about this, and there's no prejudice or harm because he's known.
Is that correct, Mr. Carter?
I was aware of the situation. I was not aware that it was intended to be used as aggravation.
I'm going to allow the testimony.
Okay. What was the nature of your contact with Mr. McNabb?
I was evaluating him at the request of Newton DFACS.
And did you have the occasion to be working on your computer down there at the jail while you were talking to him?
I did.
And at some point in time, did Mr. McNabb tell you to look up?
He did.
And when you looked, where was he at in relation to you?
He was probably an inch or two away from the glass, right in front of my face.
So were you separated by glass?
We were separated by glass.
And what did you see when he asked you to look?
He was wearing a turtle suit, which is something that prisoners are wearing when they're on suicide risk. And he wasn't wearing clothing under that, and he had pulled up the turtle suit and taken out his penis and was masturbating.
And did he masturbate to completion in your presence?
He did.
Thank you. Those are all the questions that I have.
No question, John.
I got a question. Can I address the court, please? I just got one thing I want to say, and that's it.
Excuse you from
I'd like to say it in front of her since she's the one accusing me.
I'm willing to allow you to talk when your time comes. And your time, you can say anything you want to. Is there any further evidence in offering of aggravation?
No, Judge.
Mr. Carter, do you have any evidence to offer in the way of mitigation?
I believe Mr. McNabb would like to address the court.
Okay, you may do so. You may stand up and address the court.
I'd just like the court to know, as well as everybody at home, since this is being broadcasted for whatever reasons, that I did have on a turtle suit, and it velcros, and it wasn't on properly, and it didn't fit properly, and the velcros were not on good because they don't stick, because they've been used for so many years by so many different people, and I was not masturbating at all in front of her, period. The thing fell off when I stood up, and that was it. There was none of that. And I would have liked to have told her that, since she was the one making the accusation. Since I'm pretty sure by the law states that I have a right to confront my witnesses who accuse me of doing wrong. So I felt like I wanted to say it in front of her, since she was the one up here slandering me. And that's all I got to say.
You sure you don't want to talk about the sentencing and all of that? That was the only thing you wanted to tell the court?
I mean, I haven't heard anything about a sentence. I was just
Sentence
commenting
you
on that. I
for the
understand that.
charges. And I just wanted to know if you had anything you wanted to say to the court.
I mean, I
prior
got a lot to
sentencing.
say. I got a lot to say, but I'm not going to be able to say half of it.
I don't know, because I don't know what you're going to say.
I'm innocent. I didn't do it.
Okay.
I've maintained that the whole time. I feel like there was things that were allowed to be said that should have never been allowed to be said, that didn't have nothing whatsoever to do with the case and what was being said. Just because somebody has domestic abuse issues with their spouse doesn't mean that they would put their hands on their kids, which has also been pretty much proved that I've never touched my kids in any harmful manner whatsoever. I've never harmed my kids. I didn't even hear anything that said that I had done anything to her in front of the kids. So that doesn't make sense either. And, you know, just to let the record show that I don't think I ever put my hands on her in front of those kids. And I just don't feel like just because somebody has domestic issues with the female in their life that they love, that they were just able to just say, oh, he don't love you and all that stuff just in front of everybody or whatever, which doesn't matter. But I just don't understand how you find somebody guilty of doing something to a 15-day-old baby, because there was no evidence whatsoever that proved anything about me putting my hands on my kids. I've never done it. I never would. I don't believe in it. I was beat as a child, and I don't agree with it at all. And I would never do it. I would never do this. That's all I got to say. I would never do it. I'm innocent.
Well, I can make a lot of comments on what you said. I can make a lot of comments on the trial, but I know that was just be arguing with you or talking with you. I'll ask you one simple question. You claim you're innocent, so you tell me what sentence the man or woman that you claim did this should receive.
If you ever find out who did them, they deserve to be under the jail.
Okay, so they ought to get the maximum sentence.
Most definitely.
Okay. On the crime of malice murder, I sentence you to life in confinement without parole. On concealing the death of another, I sentence you to 10 years in confinement consecutive or after. Count one. Do you understand each of your sentences?
Yes, sir.
I want to advise you that you have 30 days after today to file a notice of appeal
It'll be filed.
on this case. I'm going to instruct Mr. Carter on behalf of you to file a motion for a new trial to make sure your rights are protected. If you wish to allege that Mr. Carter did not do an effective job, then we'll bring in another attorney to handle the appeal so that issue can be raised, and that's fine with Mr. Carter. He takes no offense.
I think he did an incredible job.
Well, that's fine. I'm just indicating to you that in order to claim your attorney at trial was ineffective or did not do a good job, you have to raise it at the earliest moment, which would be here.
I won't be filing anything against my attorney.
That's fine. I also want to inform you that if the case is appealed, if the Supreme Court of Georgia affirms your case, you have 4 years from that date. The affirmation is made in what they call a remediator. The case is sent back down here to file what is known as a writ of habeas corpus, claiming that your body is still being held illegally and unconstitutional. It has to be done within 4 years of that date. 4 years and 1 day, they would not listen to it. So do you understand that right also?
Yes, sir.
Any further rights I need to advise from anybody that you know about?
No, sir, Your Honor.
Okay, take Mr. McNabb on back. Let's bring her out. Let's turn now to a sentencing hearing on Ms. Bell. Does the state have any evidence it wishes to offer in aggravation?
No, Your Honor.
Mr. Frost, do you have any evidence you wish to order in mitigation?
Judge,
Offer?
I would just like to state that Ms. Bell's crimes, as found by the jury to be guilty, were more of her being a willing victim, and that spilled over into what happened as to her children. It's terrible, and it's extremely sad that that happened, but I don't think that, and obviously she was not charged to the level that Mr. McNabb was, and I would just ask the court to take those factors. She didn't have the opportunity of having an upbringing, as I think I discussed in my closing. She had no role models for that. She was suffering from addiction and abuse, and should she have done something? Yes, she should have. She didn't, and that's what led her here. And but I think that there's through courses, coping mechanisms, things that she might learn through prison classes and afterwards, there would certainly be the possibility of her being someone who could be a productive member of society if she were to embrace some of those things and put them to use in her life. So we would ask the court to take those into consideration. Thank you.
Does your client wish to make any statements?
I didn't do this.
Stand up, stand up.
Y'all know I didn't do this.
Ms. Bell, you and I had a conversation
We did.
back in chambers on Wednesday, remember, morning? And at the time I told you there's a difference between the reality of the situation and what you think. I explained to you exactly why you were being charged with the crimes. It wasn't that you knew about the murder, it wasn't that you anticipated the murder, it wasn't that you planned the murder, any of those things. It was simply that you created an environment that caused your children to be put second and Mr. McNabb to be put first. As the state said in their closing, and they used the example of a rattlesnake being thrown into a room and the child being put into there. Well, your whole claim is I took him back because I wanted to have a family. In that analogy the state used, it's just kind of like saying your child's dead from a rattlesnake bite. Why would you put it in there? And you responded, well, I just wanted her to enjoy nature, have an appreciation of the outdoors, without appreciating the danger. Now, I'm sorry, but for you to go around chasing McNabb, doing meth, flies in the face of what any normal mother would do. We hear stories out in society, I mean, out everywhere. The mother bear that's so ferocious. Why? Because you're messing with their child. All those kind of things. And you chose methamphetamine and McNabb over a baby.
It's a sickness, but I tried to be a good mama. I love my babies.
The problem, Miss McNabb, is that, like most criminals, you have this version of what a good mama is that is so far from the norm that, you know, you go anywhere in this county, talk to anybody who's watching this and say, is it a good mama who doesn't even care about her 14-year-old baby? Put them with a cousin. I've known of instances where mamas won't even let in the first couple of weeks of a child's life people around the child for fear that the child's immune system hadn't been built up and they don't want germs brought into the child. They go to that extent. You went just the exact opposite direction. And there's just no excuse for that. On count, well, let's talk about this. Count 2 merges with count 1.
Yes, Judge.
What's the thought about count 3?
I think it's fine, Judge. It does not merge.
Okay. On count 1, I'm going to sentence you with 30 years, with the first 15 years to be served in confinement in the state penitentiary, the remaining time on probation. On count 3, I'm going to sentence you to 10 years in confinement and run at the same time as count 1. Now, do you understand your 2 sentences? Let the record reflect she's nodding her head slightly yes. And Ms. Bell, I'm going to give you the following rights that you have. Within 30 days, you have a right to appeal this case to the appellate level. You may start that process with a motion for new trial, which I'm going to direct the attorneys to file, just that skeleton general motion.
Yes, sir.
If at the time you decide, Ms. Bell, you can allege that your attorneys did an ineffective job. They just didn't do a good job. It has to be brought up at its earliest moment. The attorneys do not get their feelings hurt if you choose to do that. And we would appoint a conflict attorney to come in and take over the appeal. Do you understand me clearly about that? I need you to stand up first off. I need you to start verbalizing.
I understand.
Okay, because she's making a record on all this. It all has to be taken down. I'm also going to advise you that if the case is appealed to the appellate level and the appellate level affirms that case in the verdict and sends it back down for the service of the sentence, you have 4 years from the date it comes back down to file what is known as a writ of habeas corpus. That means I'm being illegally detained unconstitutionally, and I want my body out of jail. But it has to be done. It's a time-sensitive thing, and you only have 4 years to do that. You understand that clearly?
Yes, sir.
Now, do you have any other questions? Okay, take her on. Yes, ma'am.
The max on count 3 is 5 in confinement, Judge?
Is it 5?
Yes, sir.
Then it would be 5. Whatever the max sentence is, it'll be 5 years
concurrent.
confinement, concurrent. Okay, you may take her on back.
Yes, I will.
Is there anything further required of the court on either side?
No, Your Honor.
No, sir.
We'll be in recess then. Thank you.
Breaking news. 2 parents are convicted of killing their newborn baby. The jury came back with a verdict within the last 45 minutes.
Here's what we know. 𝐬𝐭𝐫𝐚𝐥 McNabb was only 2 weeks old when her body was found in the woods, a few hundred feet away from the family's home in Newton County. Just moments ago, the mother and father made a tearful plea before the judge right before he sentenced them.
That I've never touched my kids in any harmful manner whatsoever. I've never harmed my kids. I didn't even hear anything that said that I had done anything to her in front of the kids.
The judge ultimately ordering the mother, Cortney Bell, to serve 15 years in prison. The father, Christopher McNabb, sentenced to life without parole.
John Sherrick has been in the courtroom today in Covington. John, what was the reaction like there in court? We saw a lot of emotion.
The judge announced the verdict very quickly. The jury got the case at 3:03 p.m. and just after 4 o'clock, the jury announced that it's reached a verdict. Judge John Ott published it.
Each verdict form reads, in each of the counts against each defendant, we, the jury, find the defendant guilty. That's all 3 counts against Ms. Bell and all 8 counts against Mr. McNabb.
And the parents seemed stunned when they heard guilty on all counts, both parents guilty on all counts. They had always insisted that they weren't the ones who murdered 𝐬𝐭𝐫𝐚𝐥. She was killed from blunt force trauma to her head in October 2017. And throughout this trial, the prosecution admitted that there was no direct evidence that the parents are the ones who killed 𝐬𝐭𝐫𝐚𝐥, but they said there is a mountain of circumstantial evidence that points to, according to the prosecution, the fact that no one but the parents could have killed 𝐬𝐭𝐫𝐚𝐥. The father accused of killing her, the mother accused, and now both of them convicted, of allowing the conditions to persist that led to her death. The jurors left quickly after the judge published the verdict. Many did not want to comment, but this has been a very difficult case for the jurors. They had to look at the autopsy photos. They had to hear some very excruciating testimony about 𝐬𝐭𝐫𝐴M's brief 2-week life and her murderous death.
It was hard seeing a 14-day-old baby. You know, anybody's got kids or a parent, grandparent, it's got a lot to do with it, and just the brutality of it was pretty hard.
What do you make of these 2 parents? What was going on in that household?
A lot of it's just the circle they lived in. It just needed to be broken.
Chris McNabb, defiant to the end, as you just heard. He stood before the judge, and the judge sentenced him to life without parole. The judge asked McNabb, do you have anything you want to say? And McNabb said again, I am innocent, I didn't do it. The judge, Judge Ott, then said to McNabb, well, for whoever did do this to your daughter, who you claim to have loved, what would you recommend for the sentence? And McNabb said, I'd give him the maximum punishment. And the judge said, that's what I'm going to give you, life in prison without parole. Moments later, Cortney Bell, the mother, stood and in tears said again that y'all know I didn't do this. The judge sentenced her to 30 years in prison, actually 30 years to serve, then 15 years on probation.